Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkar. Normally, I am also of opinion that every police officer, particularly the investigating officers or the officers who are attached to Law and Order Division, they are well aware of the Arnesh Kumar judgment. So, very famous judgment, Arnesh Kumar versus State of Bihar, 2014. This is a classic judgment, a landmark judgment regarding the arrest of persons and 41A CRPC notice. So, if the person commits an offence which is below 7 years of punishment, then the police officer, instead of arresting him, he can serve a notice under section 41A CRPC, and if he complies with the same, the police officer can just send the notice to the court and he need not arrest the accused. This is in everybody's knowledge. But Madras High Court actually expressed shock at the ignorance of the SI regarding the Arnesh Kumar guidelines, right, regarding arrest. It happened in Madras High Court. So please, this relates to the case law L.Muruganathan versus the state of Tamilnadu, and 3 or 4 other parties also there. SI Dharapuram is one of the respondents. So it was disposed on 29/11/2022 in WP number 22431 by 2012 by two judges bench, Justice R. Subramanian and K. Kumaresh Babu. Actually, they expressed shock at the innocence or ignorance of the SI regarding the so-called Arnesh Kumar guidelines. Incidentally, the SI was present in the High Court. Actually, this is an appeal and cross-appeal also. If you go to the facts of the case, then it will be better for you to know the details. So this is also an incident which occurred to a disabled advocate. So Mr. Muruganathan, he is a physically challenged person. Of course, he studied law, but of course now he is not doing. Actually, he is suffering from Becker's muscular dystrophy, which is actually worsening his locomotive disability. So very recently we have come across the myositis too, the very celebrity cinema actress Madam Samantha. So likewise, this is a physical disability, and the doctors, so the team of doctors, they have examined him and they have given a certificate that he is having 80% physical disability. This is what he is a physically disabled man. That means he has to be treated as per the Act of Rights of the Physically Disabled Persons Act 2016. Right, this one point. Second, now coming to the facts of the case, the SI Dharapuram, Dharapuram. So arrested the so-called physically challenged Muruganathan on 29/2/2000 at 10:15 a.m. On which basis? On the basis of the false allegation given at the instigation of his paternal uncle, Mr. Dandapani. Actually, it's a dispute, that too dispute regarding a place for tethering the cattle. Godlu kattukune chota tagada. So he wanted to convert the matter into civil matter into a criminal case, and he has incited some of his people. They filed a case against our Muruganathan. So of course they registered a case under section 295, then 506 clause 2, and also 323, I believe, 3 sections. 294B, 323 and 506 clause 2 of the Indian Penal Code. Except this 506, all others are non-cognizable offences. You know that. Anyway, since there is a cognizable offence, the SI, so he has arrested the so-called Muruganathan, basing on the complaint given by Mr. K. Selvakumar, who is the henchman of his paternal uncle Dandapani. Right? Already I told you, this is for settling the scores in a civil dispute. So therefore, very nicely they have converted the civil case into a criminal one. No doubt, at 10:15 a.m. he was brought to the police station, but literally the arrest was shown at 1:15 p.m. and he was produced before Magistrate. So even though the physically challenged person, Mr. Muruganathan, appealed to the magistrate that the police have shown unnecessary delay in the arrest and other things. The police have, I think, slapped him. The SI slapped him and also kicked him also, beaten and slapped by the SI. So when all these facts were brought to the notice of the judge, he did not say anything. He simply remanded him to judicial custody. Later, he got bail. So, vexed with the attitude of the police, he approached the superintendent of police as a supervisor officer. So he approached the superintendent of police, but no justice was done to him. Then he has approached the State Human Rights Commission. He has actually expressed with a pitiable condition, SHRC. Definitely, it was satisfied with the allegations filed by our Muruganathan. They have conducted inquiry. Ultimately, even though the police said that they have arrested him as per the due process of law, then SHRC did not agree and asked him to pay asked the SI to pay a compensation of 1 lakh to the said Muruganathan. Right? Muruganathan filed a writ petition before the Honorable Madras High Court for excess payment of the compensation. That means 1 lakh is enough, so he has to pay 50 lakhs also. The SI police, on behalf of the state, they have filed a writ petition that even though they followed the due process law, unnecessarily they are asked to pay compensation by the State Human Rights Commission. So both these petitions came before the Madras High Court, and incidentally, they came, of course, this Dandappa Muruganathan, he filed a case against jail authorities also. No doubt, the High Court considered that jail authorities not at all concerned in this violation of human rights, only the SI. Right? So they have gone through the contents of the FIR. FIR is very clearly stated that the case registered against Muruganathan is definitely a civil case. So they wanted to convert the entire matter is stage managed. They wanted to convert it into a criminal case. Right. So in the writ petition, SI stated that SI means on behalf of the SI, the state stated that the SI followed the guidelines given in the DK Basu versus State of West Bengal 1997 case, but they did not mention about Arnesh Kumar case. Now, incidentally, the SI was also present at the court. Then the Honorable Court asked the SI, did you follow Arnesh Kumar guidelines? He feigned ignorance. He said he doesn't know the Arnesh Kumar details. Then the court was shocked. Then they have sent a notice to the DGP. DGP clearly said that they have given circulars. Of course, who will read the circular? Unless, so therefore, Honorable High Court of Madras, of course, they have given directions to the DGP to conduct training classes to the, particularly the young SIs regarding the Arnesh Kumar and other guidelines whenever a person is arrested. And secondly, another amount of 25,000 was added to the 1 lakh, and it is supposed to be paid by the advocate, the so-called SI police. Of course, on behalf of the advocate, SI, the state has to pay the amount to the so-called Muruganathan, and they can recover it from the concerned SI from the salaries. So, in this connection, Honorable High Court also discussed the topic of installation of CCTV cameras. If the CCTV camera was established in the police station, it will be very clearly stated whether the person was brought to the police station at 10:15 a.m. or 1:15 p.m. So, but still CCTVs are not installed. Of course, it's a different topic, but anyway, the Honorable High Court of Madras touched this also. So what we have to learn is the sub-inspector should be very careful, and the police department, they are expected to know the so-called DK Basu case as well as Arnesh Kumar guidelines. Otherwise, they will be queried like this, and they have to cut a sorry figure before the courts. So please read the judgment. As advocates also, please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.